have a seat. Council President, Mr. Tisdale is present. All right, consider the rule that governs this particular issue, 3.202, Florida Rule of Criminal Procedure. I read the deposition of Dr. Cunningham and at least the portion of, well, all of Dr. Gabarino's transcribed deposition. I recognize it. It didn't get finished apparently. But. All right, the defense position is these witnesses are not mental health professionals that are going to give expert testimony to statutory or non-statutory mitigating circumstances. Therefore, it's the defense position that no notice is required under 3.202D as in dog, and consequently the state would not have a right to examine Mr. Tisdale within 48 hours, assuming there's a conviction, of course. The state argues the testimony from these witnesses is or could be mental health mitigation, and seek to have their an order from this court having their expert examine Mr. Tisdale within 48 hours after the verdict, assuming there's a conviction of first-degree murder. That's difficult for me to reconcile this because even after reading the depositions, I'm still not sure whether or not it's mental health mitigation or not, because as you all know in depositions there's a lot of questions that can be asked and are asked that may or may not be admissible questions in a penalty proceeding or a trial. The second concern I have is something about this interview frankly concerns me. I mean, the rule says expert testimony of a mental health professional is to test and evaluate or examine the defendant in order to establish statutory and non-statutory mental mitigating circumstances. The defendant shall give written notice of intent to present such testimony. So, that's a term of art. One person's interview may be another person's evaluation or examination. But the defense has not filed any notice as required by the rule at least 20 days before trial. So in order to reconcile this and avoid any potential error, well, let me ask, Mr. Bagdell, is y'all's concern Dr. Gabarino or Dr. Cunningham or both?
Both.
Okay. All right, because there's been no notice filed by the defense, as I understand the rule under D, that notice must be filed first. Then if there's a conviction, then the court shall order within 48 hours the defendant be examined by a mental health expert chosen by the state. So the only way I know to reconcile this is to proffer their testimony outside the presence of the jury so that I can determine whether this is mental health mitigation as contemplated by the rule. If it's not mental health mitigation as contemplated by the rule, then there's nothing that triggers the state's right to have 48 hours to examine the defendant by their own mental health expert. If it is mental health evaluation mitigation, then I think I'm obligated to allow the state 48 hours to examine the defendant if it's mental health mitigation and any other sanctions or relief that may be appropriate. So, when, Ms. Saladonia, when are either Dr. Cunningham or Dr. Gabarino available?
Well, Dr. Cunningham is flying in Monday night, and he'll be here Tuesday or Wednesday. We didn't know which day he would be potentially testifying. And Dr. Gabarino is coming in Tuesday night for testimony on Wednesday.
All right. Are they? Oh, okay. Or Cunningham's coming Monday night?
Yeah, he flies in Monday night.
And Dr. Gabrino's coming in Tuesday night. Are they available by phone, like to proffer their testimony by phone? I want to proffer their testimony to decide whether it's mental health mitigation or not. If it's not, it's not. If it is, then they've got a right to examine.
Dr. Cunningham is what we would consider hours, Monday, Tuesday, Wednesday.